News, former Managing Director of the National Social Security Fund, Richard Byarugaba, on September 27th made his latest attempt at getting back his old job, petitioning the High Court to quash the appointment of his successor and former Deputy Patrick Ayota. Through his lawyer, Byarugaba argued that Ayota was holding a substantive statutory position of Deputy Managing Director on a fixed 5-year term when he was appointed as MD on August 18th. Byarugaba made a new challenge through his lawyer, Anthony Bazira, where he also wants his contract at NSSF MD renewed at that time. Earlier on, in August 2023, Byarugaba had sued the Attorney General and the Gender Minister, Betty Amongi, demanding that the latter to complete his reappointment process as recommended by the NSSF board. The High Court then granted his wish for an amendment to challenge the appointment of Ayota. In that regard, the High Court Judge Musa Sekana asked Byarugaba to make Ayota a part to the case so that the latter can have a right to response. Justice Sekana said it was in the interest of natural justice for Ayota to be heard as serious matters are being raised that could affect his position. That case is up for mention, and since the court has made a decision, you do have the decision and judgment on this matter having been given to us. Now, the decision does state in extraction the decision of the minister to reject the applicant's name for the appointment as the Managing Director of National Social Security Fund was within the law and irrationally has been shown in the decision-making process. The recommendation by the board of NSSF to the minister does not become a directive or an order to the minister who is vested with the powers to appoint the applicant. It is inconceivable to think that a recommendation is binding on the person or entity to which it is addressed. Recommendations call for the exercise of discretion in accepting or rejecting them. In all cases, recommendations are simply suggestions for further action. The decision to challenge the appointment of the third respondent by the Minister of Gender, Labour and Social Development based on a new recommendation of the board cannot successfully be challenged without the board being a part to these proceedings. This court, however, cannot squash the appointment of the third respondent, which resulted from a recommendation of the board. Such a decision would violate the principle of fairness and would amount to condemning the board unheard in respect of their decision to appoint the third respondent. That very same judgment did say the appointment of the third respondent was an act involving the Minister of Labour and Social Development as the minister responsible for the affairs of NSSF through reporting and exercising supervisory function after applying her mind to the exercise of power and followed the law as prescribed and should not be interfered with in absence of any justification or any breaches of the law. The court will not lightly presume abuse or misuse of power and will make allowance for the fact that the decision-making authority is the best judge of the situation. This application fails and is dismissed with no order as to cost. It's also ordered by Sekana Musa, the judge, and this is as of today, the 19th of April, 2024.